Hello everyone, welcome to BYJU'S Exam Prep. I'm Nivedita Raje and today we are going to discuss the Hindu editorial. So Saturday we have a session which is dedicated to the analysis of a Hindu editorial from a legal point of view, and we shall be discussing the most relevant editorial which has a legal connotation, the laws associated with it, and something which you might not be able to understand on your own. So good afternoon everyone. How is everyone? What is happening? Hello, good afternoon. Yes, the class has started. Yes, so this is extremely important because, like I told you, Hindus or the Hindu and the editorial, especially, they play a significant role when it comes to your preparation. Practically, because they they get picked up just like that. Like they just pick up the editorials or the articles or the opinions written by editors and people and jurists and etc. And they use it, they incorporate it that thing straight away in the in your question paper. Now this benefits you in a lot of ways. If you're familiar with the editorial, it gives you an idea of what is written in the passage, first of all. Second, you would be able to understand it in a lesser time than the other students. You already know what is happening. Also, if the editorial relates to anything legal, you also understand the legal point of view, because if it is asked in the legal section, they would expect you to know all that happened around it and everything. Is Nambi Narayan case important for us as it is coming in news? Sort of, yes, yes, it is, Alfia. It is. I was going to discuss it, but we got a little late on this Bilkis Banu judgment. Now, this is something that I really think, although it is a little bit old, it was published somewhere, I think it was there 10 days before, in 17th August's edition of the Hindu. So, the problem is that, it is not a problem, but I sincerely think that this is something that you need to know what happened in the case. How is it that it is actually a horror? It is a horrific decision by the state government that the convicts are allowed to go free, and this has led a huge impact on the minds of the people. That is why they're marching with candles and everything. When I'm getting invitations, I might not be able to get time for it, but yes, it is a horrific thing that has been done. So let us start. Remission without reform, on the release of 11 convicts in Bilkis Banu case. So this is the editorial, guys. The editorial, the first line of it, editorial says a premature release of prisoners must be done with discretion and wisdom. This is what the idea is. This is what the author wants to say. He's sort of criticizing the decision of releasing the convicts, which in my opinion is not a right date, not a right decision. The published date was 17th of August 2022. Now, this is what the editorial said. If you want, you can read it. I will give you some time. Please read it. Take your time to read it, guys. Good afternoon, good afternoon. Is everyone done reading? Should I move on? Everyone is done, right? Good. Now we shall be discussing all the laws that are there, including the section 435 of the Code of Criminal Procedure. So don't worry about it. Just read what is written and then we shall discuss. Done? Right. It was a long editorial, guys. Done. Everyone. Good. Now, what exactly is the Bilkis Banu judgment? So, Bilkis Banu basically was a victim of a gang rape. Now, the question or the controversy that arises from this decision is they're actually sort of condoning. Is it buffering? Is it buffering really? Can you guys see me moving or talking? Are you able to hear me? Everyone, you can? Good. Then let's move on. So the problem with this judgment is, guys, that they're sort of condoning gang rape. Now, gang rape is a heinous crime. Now the question is it really a heinous crime? Because if you are choosing to let the convicts of such heinous crime leave, you're sort of supporting what their actions were. You're supporting what they did. And do we really have it in us, and does the judiciary and the parliament and everybody who is empowered to do some to order this kind of grace, do they really have it in themselves to forgive such men who use their physical power to assault a woman who is not as powerful as them, right? Only audio, not video. I don't know why that is happening. My video is freezing, but you can hear me, right? So that's also fine. I think it'll work in a moment or so. It should. That's what I'm hoping for. But let's not waste our time. All you need is to hear me, so just hear me. Okay, now should the society be unwilling to forgive men who use their power to assault women? So, if people are coming on roads, they're outraged that something like this is done. They're outraged. They're on the roads. They're protesting against this decision. They want those men to be behind bars again. It is not. Society cannot condone a behavior like this. Society cannot accept that a man or men capable of doing such a heinous act can walk free. So, should the society really forgive these men? Does the brutality with which the rape is conducted matter? while deciding for the punishment or while making a decision whether or not these men should be let whether or not these men should be allowed to roam freely. So decisions like these, the decision to lessen their punishment, the decision to give them lesser punishment than what they actually deserve, should that be considered on the parameters of how brutal their act was? Now, all these questions come to mind because the decision was horrendous. Now, what is the background of the case? Now, on 28th February 2002, Bilkis Banu and the members of her family were trying to flee from the communal violence which was happening in Gujarat, right? So the mob that declared themselves to be the, you know, protector of the saffron faith were killing around Muslims, and they were extremely violent. Now, there were many people who were, you know, incapable of protecting themselves, were sent to safer houses where the violence was not as rampant. So, Bilkis Banu was among them. She was pregnant, 5 months pregnant, and she fled with a 3-year-old daughter. Now, well, the place where she was taking refuge was also attacked by these, you know, people, the mob. She was pregnant and she was gang raped by 11 men, and her 3-year-old daughter was killed by smashing her head with a rock. So all the 14 people, including Bilkis Banu's 3-year-old, were killed. The lady who was 5 months pregnant was gang raped. She was presumed to be dead because she was bleeding profusely, but a tribal family somehow saved her, and they did the unthinkable. Generally, people coming from poor backgrounds, unprivileged backgrounds, and who belong to scheduled tribes and scheduled castes are not as vigilant. They're not legally as free as other people. They're scared of police, they're scared of the system, and this is the reason why often they are, you know, not provided with justice, because they do not come forth, they don't register what has happened with them. But surprisingly, since the attack was unimaginable, uh, it was extreme, it should not have done, it could not have been committed by human beings. Human beings cannot be as vicious as what they did to Bilkis. So they mustered up the courage. Digital board, yeah, they're more lively, I know. So they somehow mustered up the courage and launched a police complaint. I know you can see me, Saurabh. This is something that I'm not able to work on. Let me try. Just give me a second, guys. Let the team work on it. Okay, so I'll continue teaching while the team is working on it. We won't waste any time. Now, the Bilkis Banu was extremely poor, and police usually do not pay attention to the weak and helpless. That is why such police complaint was unusual, because many people who suffered at the hands of the mob during these communal riots did not come forth to register their complaints. So the local police did what they were supposed to. They rejected the complaint and they cited that there were several inconsistencies, and they chose not to believe that a lady who was 5 months pregnant was gang raped by 11 men. But Bilkis did not fret. She actually fought on and took the case outside Gujarat, where she knew justice could be given to her, not in Gujarat, because Gujarat was in a different state. At, absolutely. The communal rights were extremely, you know, they were extreme. Nobody was ready to listen to anybody who was suffering at the hands of it. And they had become a divided state, a state which was favoring a major religion while the minors were suffering extremely. and the state government at that time was sort of supporting what had happened. So there was nothing that could be done, and that is why people chose not to speak, because they knew remedy won't be provided to them. The mob and the people committing the violence and committing such horrendous acts were sort of supported by the state government back then. This was the mindset, and many people in the state government were put on trial because they had a lot to do with it. So instead of registering the complaint in Gujarat, she approached National Human Rights Commission. She sought help from a National Human Rights Commission and then the Supreme Court. Supreme Court intervened, and instead of asking the local police to interrogate and investigate, they asked CBI to get involved, and the case was taken over by Central Bureau of Investigation. Now, CBI took matters in their own hands, and they were extremely active. They exhumed the bodies of everyone who was killed in the mob to figure out whether it was a natural death or whether it was a murder. And turns out everyone who was involved in those killings were arrested. So exhuming is something that is allowed by the Criminal Procedure Code. If for the process of investigation and interrogation, it is necessary that the body which are buried should be taken out, or should be taken out from the grave, that is what exhuming is. So the bodies which are buried according to the Islamic religious rites, they are taken out of their graves, and then post mortem is done to them to figure out the reason of their death. Now all the people, the 13 people, 14 people who were killed, they were exhumed from the grave. Their post-mortem was done on them, medical examination was done on them, and turned out that they were killed. They were murdered using dangerous, fatal weapons. Everybody who could be identified, everybody who was named in the mob was immediately arrested. Okay, everybody, are you guys, uh, do you understand this much part of the story? Everyone, do you get this much part of the story? Is everything clear? Is there anything that you want to ask me right now? Saurabh, I would suggest you to focus a lot on mock tests and sectional tests. Uh, I would suggest you take the exam again, like not the exam, but the 22 question paper that was there. So do that again. I think I'm moving now. Yeah, the buffer will end. I think it has ended already. It's fine. Now I'm moving. Good. You can see me moving and speaking at the same time. That is fun. Now you are good. Now I'm visible. Yes. Great. Awesome. Just let us do the final things, and then we can begin. Yeah. So we're done. Good. Great. Now, yes, so yeah, the CBI exhumed the bodies of the persons who were killed, and they were arrested for several crimes, which included homicides, manslaughters, rape, robbery. A lot of things happened. This happened when the BJP government was presiding at the center. So it was claimed that there was a lot of political pressure on the CBI to frame the accused, because many of the accused were government officials. Now that is where the problem was. Many people who were mentioned in the CBI report belong to the party, ruling party. So there was a pressure, and it was difficult to claim that there was a political pressure from the state government, because state and central government were both the same, right? Now the trial court found 13 people that the CBI had charged guilty of rape and murder and sentenced 11 of them to life imprisonment. Now, CBI challenged, yes, BJP. Now, CBI challenged the verdict and claimed that the punishment given to these 11 people is less. The punishment should be increased. And this plea was rejected. Another court upheld the convictions, but the rapists and the murderers did not get death penalty. Now, in these circumstances, it is hard to believe that the accused were innocent and justice miscarriage had happened because the judgment was pronounced, the evidence was there, and the judges were, uh, they were, yes, yes. Okay, so you're asking what BJP is. BJP is the same party that is ruling us right now, party at the center. It's guilty of a lot of, you know, I don't want to say, don't want to be a political, I don't want to make any political statement. I don't want Modi ji to charge me with sedition and put me behind bars. I'm not well to survive in the jail. Well enough, as you can notice. So, jail mein to survive nahi kar paungi main, so there is no point. So I'm not making any political statement about anything. Now the judgment came, the people were given the punishment. CBI was not convinced. Nobody was convinced that the judgment was good because the brutality of their acts demanded that they should be given death sentences, but they were not. And it could not be said that there had been a miscarriage of justice because the judges were confirmed that the evidence that support their guilt is only enough to give them life imprisonment, and that is enough punishment for what they did. Although it wasn't enough, but there could be nothing that could be done about it. Yep. So now the question is, why have the convicts been released? That is what the editorial is talking about. I'm sorry if I can't do it. Why don't you just leave the class if I'm not able to do it? I mean, don't attend the classes if I'm not able to clarify your concepts. What can I do? Okay, so yes. Now the problem is that the convicts that have been released, yeah, it sort of took me back. Just give me a second. Free rights about what? Free right to say anything? Not really. Not really. You can't really do it. I mean, it's a it's an extremely radical government. Whatever you say or do is sort of, yeah, I'm trying not to. Thank you, Himanshu. I'm trying not to. Free speech. Of course, you have free speech, but the question is, Ayushman, do you really have it? I mean, this is a free democratic country and you are free to say anything that you want, but the thing that I am trying to say is that, free speech is sort of restricted. And when the government is overly sensitive, your fundamental rights gets affected a lot because you don't really know what might affect their ego and what might land you behind the bars. Now, this is something which is extremely unpredictable, and this is something that you need to stay away from. Okay, so that is what it is. Now, the problem is, or the things that are being discussed in the Hindu, or the reason why the editorial is written, is as to why these people are even released. Why, what has happened that their brutal, immoral, extremely heinous act has been overlooked and they are being allowed to roam freely. ऐसा क्या हुआ है? So that is what the editorial is discussing, and that is what we are also going to discuss. What is the policy? What is the law? Does the law really allow these people to roam around freely? Of course, this is not fair, but life isn't fair, Ayushman. Life isn't fair. As you can see, I'm being targeted for something that I don't think I do. I think I teach well enough, but there are complaints. So life is not free. People are never satisfied. What can you do? Now, the Radheshyam, one of the convicts, one of the 11 convicts, he approached Gujarat High Court seeking remission of the sentence under section 432 and 433 of the Code of Criminal Procedure. Now, what are these sections? Section 432 deals with the power to suspend or remit sentences. Now, according to the section, the appropriate government has the power to unconditionally or by imposing conditions, unconditionally as in without any condition, or by imposing a certain condition, accept a convict's plea or and suspend the execution of their sentence. For example, let's say we have A. Okay, let's say we have A and he's been inside jail for quite some time. Now he makes a plea to the appropriate government under section 433 of IPC. His sentence is 20 years of life imprisonment. Okay, sorry, 20 years of jail. And he hasn't been jailed yet, like they are yet to execute the sentence. So before the sentence is executed, he'll approach the appropriate government. If the appropriate government finds it fit, they will suspend the execution, meaning thereby they won't send him to jail and his execution will be suspended. You know what suspended is? Like if you have been suspended from school, I was once, I was in 8th. So yes, so he does not have to go to jail. Now this government can put certain conditions on him that if you are supposed to do this while you are outside the jail. So it's yes, of course they have the power to do it. Oh, you're talking about my suspension? Oh yes, I was suspended. That's okay, it happens. I enjoyed the week. So he doesn't have to go to jail. He can continue this imprisonment outside the jail. So he will be inside his home. He might not be able to leave the city. He might not be able to leave the country. So these are the things that, these are the conditions that the government can put on. Or the appropriate government can remit the whole or any part of the punishment. Remit as in reducing the intensity of the punishment. So if a person is getting life imprisonment, it can be reduced to maybe 7 to 10 years. If a person is getting death sentence, it might be reduced to life imprisonment or 20 years. So this is what remission is, reducing the intensity of the sentence. Okay, that is what. Yep, I know. So this is something that the appropriate government can do. Okay. Now section 33 is power conferred upon the appropriate government which can commute sentences of death, life imprisonment, rigorous imprisonment and simple imprisonment. Now this is something that can be done under the power given to the appropriate government under section 432 and 433. Ritik, I am sorry. Okay, fine. Guys, I will translate. Sanjana, sort of, yeah. I shall translate everything that I just said, but I am saying the same thing. I'm not adding anything new. Okay, so don't worry. The students who are not able to understand Hindi, don't worry about any new additional fact that I'm going to incorporate while I'm saying it in Hindi. I'm saying the same thing that I just said in English. ऋतिक, मैंने अभी ये बताया है कि अप्रोप्रिएट गवर्नमेंट के पास पावर है सेक्शन 432 और 433 में, जिसमें वो सेंटेंसेस के विगर को कम कर सकते हैं. तो अगर 10 साल की सजा है तो उस 10 साल की सजा को 5 साल का कर सकते हैं. अगर डेथ सेंटेंस है तो उस डेथ सेंटेंस को चेंज करके लाइफ इम्प्रिजनमेंट कर सकते हैं. और ये दोनों ही पावर्स अप्रोप्रिएट गवर्नमेंट को क्रिमिनल प्रोसीजर कोड देता है. अब इस राधे श्याम ने, जो कि 11 कन्विक्ट्स में था, उसने गुजरात हाई कोर्ट में सेक्शन 433 और 432 में एक रेमिशन प्ली डाली कि मेरे सेंटेंस को कम कर दिया जाए. दिस was what happened. Okay, now what happened afterwards? The High Court thankfully, no Sanjana, I don't. It's a full-time thing. I won't be able to teach if I own a firm and start working. Okay, so High Court dismissed the plea while observing that the appropriate government can take the decision. Okay, but the appropriate government will not be Maharashtra. Oh, sorry, will not be Gujarat. It will be Maharashtra. Why? Because the case was transferred from Gujarat to Maharashtra. Bilkis was confirmed that she is not going to get any justice in Gujarat. So her case was transferred to Maharashtra. Right now, the High Court said that the appropriate government in this case is not Gujarat; it is Maharashtra, because that is the courts that punished you in the first place. So their government becomes the appropriate government, and they'll decide whether or not the remission or commutation should be done. I shall repeat this in Hindi. हाई कोर्ट ने इस प्ली को डिसमिस कर दिया और ये कहा कि भाई तुम्हें सजा देने वाली महाराष्ट्र स्टेट थी, गुजरात से तुम्हारा केस ट्रांसफर हो चुका था। अब जिस स्टेट ने तुम्हें सजा दी है वही डिसाइड करेगा कि तुम्हारे पनिशमेंट को कम करना चाहिए या नहीं। सो यहाँ पे हम कोई डिसीजन नहीं ले सकते, महाराष्ट्र में ये डिसीजन लिया जाएगा। ओके, this was held by the Gujarat High Court. This was the judgment on Radheshyam's plea. Now Radheshyam again filed a plea in the Supreme Court, pleading that he has been in jail for 15 years now without any remission. Okay, and there should be something done about it, because even life imprisonment entails almost 14 years of punishment, although life imprisonment construes to 20 years. Now there is another concept that you should be familiar with. Everybody thinks that life imprisonment is equivalent to 14 years. No. Life imprisonment according to Indian Penal Code means 20 years. So they can give anything between below 20 years, and they can term it life imprisonment. Life imprisonment maximum 20 years होता है। 20 years तक आप कितनी भी, मतलब जज कितनी भी सजा दे सकता है और उसको लाइफ इम्प्रिजनमेंट का नाम दिया जा सकता है। 20 years से ऊपर लाइफ इम्प्रिजनमेंट नहीं होता। Beyond 20 years there is no life imprisonment until and unless it is written in the punishment section that life imprisonment would mean remainder of a person's life. So until and unless this clause is there, which was added later on after Nirbhaya and everything, the amendment that was done in 2018. So before 2018, life imprisonment meant maximum 20 years. But after 2018 amendment, if a person is given life imprisonment, he can be given actual life imprisonment, which means he will spend his entire remainder of life inside jail. But IPC has to specifically mention it. It cannot be given on a whim or that you think it is fit. No. Until and unless the section provides for that punishment, you cannot give it. Everybody clear? Is everybody clear? Any doubt whatsoever? Good. Now the apex court directed the Gujarat government. Now that is where the problem started. They should not have done it. Gujarat High Court had already dismissed the plea, citing that Gujarat is not the appropriate government here to take this decision. The Supreme Court completely overlooked what High Court of Gujarat had held, and they directed the Gujarat government only to look into the issue of remission and decide whether or not his sentence should be remitted or he should be released. Okay, now this was the problem. Before I move forward, there is something that you should know. Yes, so there were two words that I used, sorry, remission and commutation. Now, remission does not mean reducing the sentence. Remission actually means cancelling the sentence. So, if a person is inside jail for 15 years and he's seeking remission, it means that he wants to be released. So, if he is given remission, his sentence will be cancelled and he will walk free. This is what remission is. Okay, cancelling the sentence. This is remission. What is commutation? Commutation is replacing a harsher sentence with a lesser sentence. So changing the nature of the sentence, for example, 10 years reduced to 5 years, death sentence reduced to life imprisonment. This is what commutation is. While section 432 provides for remission, section 433 provides for commutation. Both the decisions can be taken by the appropriate government. Okay, now when the Gujarat government was asked to look into the remission plea filed by Radhesham Shah, the Gujarat government formed a committee. Okay, now a committee was created. It was headed by Panchmahal's collector Sujal Mayatra. He was the head of the committee. This committee took a unanimous decision and declared that all 11 convicts should be released. Now, the thing that disturbs me the most, and the things that has disturbed everyone else, is that the government, the Gujarat government, approved this decision. And on Monday, the Monday that was before 17th of August, the 11 convicts in the Bilkis Banu case walked out of Godhra jail. That is what has happened. Okay, everyone clear? Exactly, Sanjana. This is something, this is the first thing that I discussed. How can they even consider giving remission to people like these? The the deterrent that is incorporated in the society by creating a fear of imprisonment and penalty is to scare people so that they don't commit offenses. The punishment, the entire criminal jurisprudence is there as a deterrent, so that people should know that if they get caught, they will be punished, their entire life is destroyed. That is what the entire objective of criminal law is. But if you start considering pleas like these, people will have no fear. They did the act. How do you really, can you really believe that people like this would have conscience? That they would be like, fine, we committed the act, we spent some years in the prison, so what? We'll be out, we'll do it again. What is there to make them not do it again? What deterrent can you impose on them if you are already remitting them of the heinous act that they did? Right? So the question is, not everybody gets remission, that is true. But the problem with this decision is that anybody, out of anybody, these people did not deserve remission. The act that they did, the crime that they committed is horrific beyond imagination. Such brutality, such viciousness, no humanity whatsoever. How can you expect humanity when you are not behaving like humans yourself? Even Bible doesn't support it. And the fact that our Gujarat government is so readily approving the remission and the release of such horrendous criminals is beyond any explanation. Okay, now since law and order, police and prisons are state and subject, sorry, police and prisons are state subjects. Everybody knows the 7th schedule in the Indian Constitution. Why do these people even have the power? Yep, political considerations, a lot of things, trying to show the world their, trying to show the minority their inclination towards majority, trying to instill fear in the minority that no matter what happens to them, justice will not prevail in their lives because the government does not support their religion or their beliefs. And the fact that they come from a minor religion is not supported by a secular state such as India. That is what they're trying to portray. This is politics. This is not politics. This is insanity. This is this is completely ripping, unraveling the fabric of democracy. And this is very, very bad. There's no explanation. Now, the reason why we have section 432 and 433 in place is because police states and prison, law and order, and everything that comes under is a state subject. Okay, so appropriate government automatically becomes the state. However, there is a proviso because there's always a chance that the state government might be biased. So, as to reduce or to neutralize that bias, we have section 435 also, where you are required the consent of the union. So, the consent of the union government is prerequisite uh, if there was a case that was investigated by a central agency such as CBI, and the convicts or the people who were investigated by CBI were later on convicted. So prisoners like these, if you are deciding to remit their state imprisonment, you need union government's consent. Do you understand, or do I need to explain this again? Do you understand, or do I need to explain this again? Everyone? I'll explain this in Hindi. Then I'll explain this in English. Section 435, 432 और 433 के बायस को न्यूट्रलाइज करता है, क्योंकि स्टेट गवर्नमेंट बायस्ड हो सकती है, बिल्कुल हो सकती है. State government can be biased towards a major religion in their own state, or the religion to which they, you know, again, okay, the religion to which they belong to. So we have section 435 also, which says that if there is a case which was investigated by CBI, okay, so if there was a case which was investigated by the CBI or any central agency, and the accused in that case were convicted, okay, were convicted. So if you are releasing or remitting the punishment of such convicts, you need to get an approval from the central government also, because while the case was tried, investigated, central agency was involved, not the state agency. तो अगर केस को इन्वेस्टिगेट करने वाली कोई सेंट्रल एजेंसी थी जैसे कि सीबीआई, और उस केस में उन लोगों को सजा मिल चुकी है और उस सजा को तुम रेमिट करना चाहते हो, तो तुम्हें सेंट्रल गवर्नमेंट से परमिशन लेनी पड़ेगी, क्योंकि सेंट्रल एजेंसी ने उस केस को इन्वेस्टिगेट किया था. ये सेक्शन 435 कहता है. अब this decision or this section was upheld by Delhi High Court in 2021 judgment, which said that section 435 is mandatory, which makes the consent of union government mandatory. Okay, but as we know, who is the union government? Right. Now, what is the reason for such outrageous decision? Gujarat's additional chief secretary, Home, Rajkumar, he defended this decision, and he quoted, he was telling certain news agency that the Supreme Court has asked to consider the early release of these 11 convicts because there was a certain remission policy which was existing when they were pronounced guilty by the trial court. So, the ex post facto laws applies, and since they were tried and they were convicted when the policy was in force, they should get the benefit of that policy. That is what Rajkumar said. What is that policy? What is that policy? Now, remission of the sentence, like I told you, it's not the reduction. Basically, it's completely, letting the prisoner go, completely cancelling his state, what should I say, imprisonment or sentence. Now, prisoners are often granted remission of sentences and they're released on important occasions. For example, if there is a birthday of some very prominent leader or death anniversary of something very, very prominent, such as a revolutionary or a freedom fighter. So this year, as part of the celebration of the Azadi Ka Amrit Mahotsav, the government issued guidelines to states and the union territories to grant special remission to the prisoners who have completed half of their sentence, okay, including the male convicts who are above the age of 60 or who are extremely ill, or women or who are transgender prisoners who are above the age of 50. So people who have already served half of their sentence, and people who are aged, people who are not well, people, women, transgenders, they should be released as the celebration of Azadi Ka Amrit Mahotsav. Now these prisoners were to be released in three phases. First was done on August 15, which is Independence Day. Then half would be released on January 6, January 26 later on, Republic Day again, and again on the second Independence Day in 2023. So this phase, this release or remission was to be conducted in three phases. First of which already happened on August 15, 2022. The two will continue in 23 on Republic Day and Independence Day. Right. Now, the president has and the governors have the power to pardon, suspend, remit, or commute the sentences passed by the courts under Article 72 and 161 of the Constitution. This is something that I want you to read. This is your homework. Okay, this is your homework. I will ask you questions in the next lecture relating to this. So make sure that you are doing your homework. Article 72 and Article 161, you are supposed to read on your own. Understand the powers of clemency given to the president, the executive head of the union and the state. And you will be quizzed on it in the next session, which is getting conducted tomorrow at 8 p.m. I will quiz you on this. Okay. Now this is section 432. You can read it again. Under section 432 of the CRPC, the state governments also have the power to remit the sentence as prisoners are state subject. However, the remission is restricted by section 433A. As per the law, if the person gets life imprisonment sentence for an offense in which death is also one of the punishment, or where death sentence has been commuted under section 433, then such person shall not be released until he has served at least 14 years. 433A. Governor has the power to give pardon, but not pardon in a death sentence. Okay, you read it, you will figure out. Section 433A says that if there is a person who was given a life imprisonment, let's say a person was punished under section 302, okay, which provides punishment for murder, section 300. Now the punishment for murder is 10 years or life imprisonment or death. Okay, these are the three punishments that can be given, not three of them together, any one of them. Okay, so let's say that A was a convict of murder and he was given life imprisonment under section 302. But this section 302 has death penalty also. He could be given death penalty, but he wasn't given death penalty. Instead, he was given life imprisonment. Do you understand this much? एक आदमी है जिसने एक ऑफेंस किया है, उस ऑफेंस की सजा डेथ पनिशमेंट भी है, लाइफ इम्प्रिजनमेंट भी है और 10 years भी है. उसे डेथ पनिशमेंट नहीं दिया जाता है, उसे लाइफ इम्प्रिजनमेंट दे दिया जाता है. ठीक है, this is the situation. Now 433A says that if this is the situation where the person has been given life imprisonment instead of a death penalty, then before you invoke section 433, okay, before you invoke section 433 and you decide to commute his sentence, you have to make sure that he has served at least 14 years inside the 14 years inside the jail. So before you take the decision under section 432, before you decide to either commute or remit the sentence, you need to make sure that he has spent 14 years in the prison. Only then you can either remute or commute his life imprisonment. Do you understand this much? Everyone? Yes, IPC is part of criminal law. Criminal law is huge. Indian Penal Code, Evidence and Criminal Procedure Code are the main dimensions. But there are other criminal statutes as well. Okay, so POXO is also a criminal statute. Any law that punishes is part of a criminal law. Okay, yes. Now, what is Gujarat's remission policy exactly? 1992, Gujarat notified a policy that allowed the prisoners to apply for remission. So at the time when the crime was committed, during their commission, this policy was in force. During when the Bilkis Banu was raped and they were convicted, this policy was in force. Now, Supreme Court in 2012 invalidated the policy, and the Gujarat government formulated a fresh policy in 2014 based on the directives given by the Supreme Court. Now, the new policy listed the cases where the remission could be granted, where the remission could not be granted. So, the prisoners who were convicted by CBI and where the prisoners were convicted for rapes and gang rapes and murder, they could not be remitted. This was the new policy. Understand me clearly. The new policy said that the people who were convicted by CBI on charges of rape, murder, and gang rape, they will not get the benefit of the new policy that was given or that was laid down in 2014. And it was based on the Supreme Court directive, which clearly said that people convicted of such heinous crime should not be given the benefit of remission or commutation. That is why they had to scrap their old policy, which allowed remission to rapists and murderers also. Now, these rapists committed the rape when this old redundant policy was still in force. And this is what their primary defense is, that we came up with a policy where we allowed people to file for remission. Now, although the policy is scrapped, we don't use it anymore. But the time when the policy was in force, these people committed the crime. So, by the effect of ex post facto law, they get the benefit of the old policy. Do you understand? Everyone. You get it, right? Hmm. Now, why did these rapists got remission? Because the 1992 policy did not have the restrictions that were there in 2014 policy. And Shah sought remission under 92 policy. Right? That is why they could file for remission and that is why they got the remission. Also, Rajkumar said that according to the CBI order in 2008, nobody was prevented from applying for remission. So Radhe Shyam Shah had full right to apply for remission and we gave it to him. Now the play of Article 20 in Indian Constitution, this is something that you should know. Although Article 20 lays down for 3 rights, we are only focusing on the ex post facto law. Can you let me know your name? Can you give me your details here? I'll share them with the team. CLAT user student 4, we can forward your concern to the respective team. I need your details, sweetheart. Your email ID would work or your name would also work. Okay, or you can call the counselors, they will give you an appropriate suggestion. Okay, yes. Now, ex post facto law, Article 21. What does it say? It says that if I think you can, there shouldn't be a problem. I mean, there is no such rule against it, so I think you can. All you need to do is speak with the counselors. Although you don't have to change, like, the classes are available to you. Yep. So now, ex post facto law, this is something that you really need to understand, so stay with me. Now, ex post facto law says that if there is a law that came on 1st January 2020 and it declares a certain act as an offense. Now, before 1st January 2020, this act was not an offense. After 1st January 2020, this act is now an offense. Now, ex post facto law says it prohibits the retrospective application of law, which means that any person who has committed or done that act before 1st January 2020 will not be punished. Any person who does that act after it has become an offense, which is after 1st January 2020, will be punished. So everything done before the law came into place is not subject to that law. The only acts that are part of that law are the acts committed after the law got enforced. This is what Article 21 says. So if there is a new offense, a person who has already done that before the law came into force will not be punished. If the penalty is increased, for example, if let's say the punishment used to be 10 years, or and now the punishment is life imprisonment, and the person was convicted back when the punishment was less, 10 years, he will continue serving the 10 years. Only people who would get life imprisonment will be the people who committed the act after the change was made. So this is the application of ex post facto law, but guys, this is the only application. In case a new offense is created, people will get benefit of the old law. Okay, they will not be subject to the new law. If the penalty is increased, they would not be subject of that new penalty. This is the only effect of Article 20 clause 1. If the penalty is decreased, the person will get the benefit of the new law. So if a person is serving life imprisonment and after a certain change the punishment for the same offense is reduced to 10 years, that punishment will be decreased. So if there is a benefit that somehow decreases the penalty or the imprisonment, Article 20 clause 1 doesn't apply. Also, if there is a change in the procedure, civil or criminal, the person will be subjected to the new procedure, not the old one. So Article 20 clause 1 has a limited application only when the new offense is created or when the penalty is increased. Everywhere else, Article 20 clause 1 does not apply. Now, since this 1992 policy is sort of giving them a benefit, this will not come into play and the old law will apply. Did you understand? I sort of confused you, didn't I? 2014 remission policy does not apply on them. Why? Because it is creating harshness. It is increasing penalties. So according to Article 20, if there is a law which increases the penalty, it will not apply to you. That is why old law is being applied to them, not the new one. Got it? So this is what the play of Article 20 is in this uh, entire scenario. You can read it if you want. Article 20 clause 1 of the Indian Constitution prohibits ex post facto laws. The expression ex post facto means a law which imposes penalties or convictions on the acts already done and increases the penalty of such acts. In other words, ex post facto law imposes penalties retrospectively. So the Dowry Prohibition Act of 1961 came into force on 25 1961. Anybody guilty of taking dowry before 25 1961 will not be punished. Okay, so this is what it is. I have already explained this to you. So this is all for today. I hope you understood everything. Bilkis Banu judgment, the related laws, Article 20, Section 432, Section 435, Section 433A, Section 430, 433, the new policy, the old policy, whatever happened. I hope everything is clear. So this was it. Now I would request you not to form an opinion and stick with the passage if at all it comes in your exams. I shall be taking your leave. Tomorrow we shall meet at 8 p.m. Be there. I would be discussing something very important, which is Supreme Court judgments. When I have you done all those 20 mocks? Are you done with all the 20 mocks? If you have, then I can forward the request. 20 mocks are a lot, buddy. Self-incrimination means harming oneself. So if I have committed a crime, police cannot make me say, yes, I did it. That is self-incrimination. So if I jeopardize myself by admitting to my guilt or by giving them all the evidence against me, that is self-incrimination. So police cannot compel me to provide evidences against me. Nobody can compel me to provide anything that goes beyond my not all are released, then they will be released. Slowly they will be released. So I am not under a mandate to provide anything that would prove my guilt and not prove my innocence. That is self-incrimination, which is not allowed by Article 20. So a person is not under a mandate to provide anything which may go against him or which may prove he is guilty. That is self-incrimination. And that is it for today. I shall see you again tomorrow at 8 with Supreme Court judgments. Take care, everybody.